Yakima County Prosecuting Attorney, elected official Joe Brusic is
right
here, right here,
right there.
in our studio, sitting right next to Lance, 6 feet apart.
That's right. That's right. Ward's
Everybody who
mask
comes
coming
in demands to sit 6 feet away from Lance. I don't know what that's from, but that goes way back pre-COVID. I have no idea. Maybe, Lance, you could explain that sometime. But in the meantime, here's Mr. Brusic. How are you, Joe?
Good morning, gentlemen.
Joe's like, "Are you guys done?"
Yeah, Joe's going like,
Once
tapping
again,
his
this is
watch
like a
like
comedy show.
tapping his watch, going, look at the time. Got to go, fellas. Thanks for having me.
Oh my goodness, what's going on with COVID in the courts?
Well, first of all, as I always say, and I truly mean this, it's an honor and privilege to be on your show. I appreciate it. You have lots of different people that you could ask on, and it's a privilege that you ask me as a representative of our great office, Yakima County Prosecutor's Office. Thank you.
Got it. You got it. Yeah.
Well, a lot going on, obviously. There's a lot of issues out there in the criminal justice system and civil justice system as well. And obviously, Superior Court and COVID, it's been an interesting last 12 months. Obviously, we're coming upon our 12-month anniversary, really, of having this truly affect us starting the first part of March of last year. And the court system, as you know, last September, the Superior Court administrator and administration really, along with Superior Court, along with the defense counsel, the prosecutors, we all worked together to really start jury trials back up after they had been put on hiatus by the Supreme Court. And since September, we've had Superior Court jury trials, less than 10. We've got another one, most likely at this point, going out a murder trial next Monday, which will obviously be a very interesting situation involving people in the selection of a jury down at the Sundome. We're still doing that. That's where we're at. Normally, in the last several trials, we've brought in about 200 people. We've had actually a pretty darn good turnout of people that have come from our community that have come in on summons for jury service. And they absolutely have done a great job.
Have you seen more of a larger percentage of people coming in?
Yeah, actually, it started off really well. We had almost 75 to 80% show up for the first couple trials. It's gotten a little less than that, but the problem is that with the questioning and with the health check that they do at the door, say of those 200 people or so, anywhere from 60 to 80 people are kind of knocked out pretty quickly.
Oh.
And so it'll be really kind of taxed this next Monday, assuming that the murder case does in fact go, and by everything it looks like it will. We're going to need several hundred jurors, obviously, more than 200 to be able to get through this. Lots of issues that go along with that.
Is this the 2 murder defendants, or because you were talking about a big murder trial that was coming up this year?
Yeah, there's several coming up.
Anyway.
Yeah.
Are these circumstances any kind of thing that if I'm a wily, clever, rascally defense attorney, then I would say, how am I supposed to get a fair trial under these conditions? We're adjusting all of these norms. Is that anything that they can fall back on, or because it's been sanctioned by the state?
That's a great question, Dave, because that's exactly what a number of individuals and Lance.
No, I'm just telling Lance. Every time I get a great question, I always have to point at Lance. That's just
we're
keeping score.
Well, but you guys work together in conjunction at all times.
Yeah, but if he
like
gets
a pack of hyenas.
Yeah, if he gets Anyway, go ahead. Anyway.
Well, but that's exactly what defense counsel believe, and whether it's right or wrong is not the issue. It's what they believe on behalf of their clients.
Sure.
Once again, every person that we charge with a crime is presumed innocent, and they have a right to obviously a jury trial of their peers, and that is part of the issue. Is that this cross-section, a jury of their peers coming in or not coming in because of COVID, they believe, whether we agree with them or not, or whether the court does, that their clients right now can't get a fair jury trial. We believe as prosecutors they can. The court believes they can. That's why we as a county have made a decision, and namely the Superior Court administration and judges, that Superior Court jury trials have consistently been maintained and have been ongoing since the 3rd week of September of 2020.
But you got a lot of backlog, right?
We do. And last week, in fact, when I spoke with you last week, Lance, there was this issue as to the backlog. Tim Rasmussen, the Stevens County prosecutor, wrote to our executive director for the Washington Association of Prosecuting Attorneys, which started a whole stream of emails from the other elected prosecutors around the state as to the backlog that we currently have. And I indicated to you that we have about 3,300 Superior Court felony cases that are backlogged. In part that came into 2020 and COVID, but also has been made worse, obviously, because of what we went through last year. And, I would say that with all the emails that we received last week and going back and forth with the other prosecutors, basically the backlogs have doubled through most of the county prosecutors' offices around the state. So it's not good. And per capita, Yakima County is very high. And this is not a good situation. And one way that it's proving to be absolutely true, especially heading into 2021, is the effect it's having on the Department of Assigned Counsel. The Supreme Court indicated a number of years ago a case that provided safeguards to having too many cases for defense counsel, Department of Assigned Counsel, and defense attorneys having too many cases that they would be assigned. So there are limitations as to the amount of cases that one particular defense attorney can handle during the course of 1 month.
Sure.
And we're running into these problems now. And this is what the backlog is starting to create. Not only is it slowing the process down, the threats of jury trials are not as great as they used to be. Therefore, you have less chance of really trying to, deal with these cases and get them completed. We need to resolve these cases, not just for the system as a whole, but especially for victims of crime, which is exceptionally important in our community, and that's what we focus on.
And when you say the threats of a jury trial, I mean, that really was. You would tell a defendant, look, I mean, you could either plea out and take our deal, or you can just go ahead and roll the dice with a jury, right?
That's right.
And most people would be like, I'm going with the deal.
Well, there's some finality to it. I mean, they know that ultimately a court is going to say, all right, you're going to trial, and then you have to make a decision. And your decision is either you go to trial or you accept the offer that has been made in the particular case. And when there's no threat of a jury trial, it does not spur that type of movement. And becomes a problem for the criminal justice system, no question.
How do you, I mean, you're overwhelmed now. How do you go back and get 1,500 cases that are sitting there in the corner? Well, when you got 1,500 on your hands.
Well, this is a problem. And, we have a meeting on this today, and, obviously, we as a county prosecutor's office, we handle every felony that takes place in Yakima County. And ultimately, we are the gatekeeper because the prosecutors, the great criminal prosecutors, we have 36 attorneys in our office.
Wow.
And 2/3 of them are criminal prosecutors, 18 are felony prosecutors, and they do a fantastic job, as do our district court prosecution team, to be able to charge these cases out. But we are the gatekeeper. If we don't charge a case out, as you know, it doesn't get into the system. And there's pressure building as to making certain decisions on these cases, and that ultimately would kind of boil down to me. I mean, ultimately, I could induce a policy as to what cases are prosecuted or not. And obviously,
so, you have to drop cases, to plea cases out. I mean, is that how you would have to handle some of those things?
Well, yeah, but once again, I do not micromanage. We have great attorneys in the office that make these kind of decisions every day, and I don't micromanage them. I trust them to be good attorneys, ethical, honest attorneys, and that's what they do. They do a fantastic job. And so we, obviously we want to reflect the criminality of a case, and we want to be able to obviously aggressively prosecute cases, which we do. However, there's also decisions that have to be made, and we make those decisions, as I've explained to you before, based upon the evidence of the case on a particular factual basis each and every time. And those are the decisions we make. But we also are aggressive, and we want to make sure that we prosecute. That's what Yakima County wants. That's what the people of Yakima County want us to do. And that's what we try to do. All within the bounds of not only ethics, but the ability for the system to deal with all these cases that we have.
7:51, if you're just tuning in, we're talking to Yakima County Prosecutor, Mr. Joe Brusic. Joe, okay, well, then I guess, you're having a meeting. You're going to try to figure it out. Good luck.
Well,
it sounds like a huge undertaking.
It's a big deal. But I also want to, the Department of Assigned Counsel has limitations on their caseload, but I just want to give a huge shout out to the prosecutors in our office. Right now, they're averaging about 110 to 115 felony cases per deputy.
My goodness.
And if you remember the Hutton report that was back in 2012, at that time they indicated not too long ago that 70 to 75 cases was the boiling point for these prosecutors to have. Any more than that, and they would become taxed. It would be a breakdown of the system, and from their opinion. And Judge Hutton was fantastic. He and Dave Thorner did a great job with their evaluation. Well, now, obviously, we've blown long since past that. Yeah. And we have anywhere from 30 to 35 murders that we're currently prosecuting in the office now. We know that we had 35 homicides in Yakima County last year. We've already had 6 this year. We had 5 in January. So 12 times 5 is 60. And that's absolutely taxing our system.
Yeah. Well, kudos that you're not micromanaging them, because we love bosses that don't micromanage. Kudos to bosses that don't micromanage and believe in their employees.
Absolutely.
Lance,
Good for you.
Absolutely.
you're a little too close to the microphone. Back up about
Sorry,
halfway.
Dave. I'm sorry. Is this better? Anyway, look, another big subject I want to talk to you about is this resentencing of juveniles that have been charged as adults, right? We've certainly seen a lot of that, a lot of those cases here in Yakima County, because we've had some very serious murders involving juveniles that were immediately put into adult court and sentenced. So what's the scoop here? What's going on here?
The Supreme Court of the state of Washington, in 2 different cases that have been conjoined, determined that we need to bring these juveniles back. There's a case that came out a number of years ago called Houston Sconiers, and basically what it does, it looks at the juvenile brain science. Once again, this issue as to juveniles and not having the capacity, of an adult brain, that their brains are still developing. The factual analysis, juveniles basically and young adults and their brains don't really kind of finalize in their processing until about the age of 25. And so the law has gripped onto this, and we know this from Miller v. Alabama in 2012 case, where we have to resentence individuals that were sentenced basically to life in prison as juveniles, but were tried as or sentenced as adults. We now have these cases that are going to glut the system. We have to bring back, because they're retroactive, we have to bring back the sentencings of these juveniles and resentence them for juveniles that were under the 18 at the time of the commission of the crime, but were sentenced as adults because of the severity of the crime.
Man, we got to have a huge list of those, right?
Well, I can tell you right now that the prosecutor for King County, Dan Satterberg, and Mary Robnett, the prosecutor for Pierce County, have both petitioned writ of certiorari for this Supreme Court decision to be evaluated by the United States Supreme Court. And they've taken a lot of heat because they both believe in juvenile reform and all the juvenile laws that are changing as we speak in the legislative session. They believe that this is not an appropriate function of the court system, that this is a legislative function. We also have a Clemency and Pardons Review Board, which can handle these, an indeterminate sentencing review board, which we've talked about before. This is their purview. But now we've got to bring these juveniles back, and it's going to be countless cases.
But it's up to you, though, right?
No, these are going to be mandatory. The other issue is the Senate Bill 6164, which is the one that would be up to the 39 elected prosecutors. This now has been codified in RSW 36 and 27130, which is the felony resentencing. And I've got about 15 to 20 of these on my desk. These are individuals that have been sentenced for, some of them, very serious crimes. They believe that their sentence does not serve the interests of justice anymore. Therefore, they're petitioning, namely me and the other 38 prosecutors, to bring them back if we believe that their sentencing doesn't promote the interests of justice, and to resentence them, obviously, to something less than what they received. And I've got individuals that have committed murder in our county that are asking to be let out, and that would be my decision to bring them back and to resentence them. And obviously this is sweeping, once again, all 39 counties as well. And it's really, it's a big deal. And some of the prosecutors, especially on the west side, are doing exactly that. They're resentencing. We have to, obviously this is the law, and we're following the law in our evaluation, my evaluation of the individuals that are promoting this and asking for the consideration of being resentenced. But once again, it's taxing this system. It's taxing the backlog. It's taxing us to be able to do our job in current prosecution of felony crimes here in Yakima County.
Has there been any kind of research done on young people that were sentenced and then got out as far as recidivism, and if we give them lesser sentences because they're not fully baked cakes and not fully responsible for their decision-making capabilities at the time, is there any kind of proof that says that's the right thing to do on the back end rather than well it makes sense on the front end, I guess, if he's not truly
Well,
accountable?
it depends on, you can find the experts that say exactly that the juveniles, that when they committed these crimes, did not understand the nature of what they were doing, and therefore they're arguably less culpable than what the sentencing guidelines caused them to suffer from. And we know this. I mean, Joel Ramos, Miguel Gaitan, the Skelton murders, obviously, Rice and McNeil on the Nikoloff murders, we have to resentence them because of it. Because each of one of these cases, they have to be evaluated and resentenced to have individualized sentencing schematics. We have to go through this. Instead of saying you're tried as an adult, you were found guilty as an adult, even though you were under the age of 18 when you committed the crime, we're now going to treat you under the sentencing guidelines as an adult. You were convicted of aggravated first-degree murder, therefore your punishment, if not the death penalty, is going to be life in prison for the rest of your natural-born life. And that has now changed because of Miller v. Alabama in 2012, and we have adopted that through Supreme Court decisions. So we have to go through the process, and we're going to be doing that. I know Miguel Gaitan is set. We've got him set for resentencing here in Yakima County the second week of July of this year.
Really?
Yeah.
Interesting.
So what do we sentence him to? Because he got life in prison without parole, right?
Yes. Yeah, that's going to be up to the court. I mean, obviously, I'm going to have, our opinion as the Yakima County Prosecutor's Office.
You get to make a case, right?
Yeah. Yes. And, in this sentencing hearing for these cases and for some of these juvenile sentencings that will be coming back, as I just described, this is going to take a lot of effort. It's a lot of resources. So it's a lot of time and energy. And I know people feel very strongly about whether this should be allowed or not. But, just as Chief Murray would sit here, I know that we've been very involved in terms of the juvenile laws that are changing as we speak. As we speak right now, the legislative session is considering, moving the age of jurisdiction from 13 to 20 as opposed to 12 to 18. And it's going to become an issue. I mean, basically, you're going to be 19 and be considered to be sentenced as a juvenile.
Well. Always an interesting conversation when we talk to you, Joe.
Oh, there's lots going on.
Man. All right, well, we'll be certainly watching this resentencing thing very closely, obviously, and especially that resentencing coming up in July, because what a horrible murder that was.
You could hear time served, I suppose, couldn't you?
Yes, that's exactly what they have.
Yeah.
They have a minimum mandatory under the new law of 25 years, and they've served that. So
well, his partner's out, right? I mean,
yes, he was. Yeah, he got out last December of 2019, and he came to our office, Yakima County Prosecutor's Office, Joel Ramos, January of 2020, and was checking on his restitution.